Aloha. I'm attorney Andre Wooten of Honolulu. And over the years, many of you may have seen our television program on public access we call Color in the Constitution. Color in the Constitution presents programs dealing with race, politics, and history in the United States, Hawaii, and the world. I became fascinated with history naturally as a young boy, actually. I remember being in the 4th and 5th grade wondering just how it was that African American people wound up being in the political position that they were in when I was growing up in the 50s. I was 6 years old when the Brown versus Board of Education decision was decided by the United States Supreme Court. And as my stepfather was an attorney, Charles M. Stokes, who was also a representative in the Washington State Legislature at the time, I was very aware of civil rights affairs and legalities, even though I was 6 years old, because I had been shipped down south to Texas when I was 3 years old and encountered my first experience with legalized Jim Crow. The history of the United States is very long and complicated. One of my favorite legal heroes was Judge Leland Higginbotham. And Leland Higginbotham was a federal judge in Tennessee. He wrote a book called In the Matter of Color, which I used as a textbook when I taught African American history and constitutional law for the Black Studies program at the University of Washington in 78 and 79. It was interesting insofar as the book charted the development of legal rights and human rights for laborers and African Americans in the 13 colonies before the United States was ever created. There was no general consensus that African Americans would be or should be treated as second-class citizens initially, and indeed in 1619 there were free African Americans in the United States, and one Mr. Samuel Johnson, I believe was his name, even owned several people that worked for him for life.
Africa. Today I'm honored to have as guest attorney Andre Wooten, who is Vice President of the African American Lawyers Association of Hawaii. He will bring to us some important and significant insights into the relationship between the Constitution of the United States and other laws that relate to and impinge upon the lives of African Americans here in the United States.
Aloha, Sylvia. Thank you for having me. History has always been a passion of mine. In fact, I used to teach African American history and constitutional law for the Black Studies Department at the University of Washington from 78 through 1980 before I moved out to Hawaii. And at that time, I used as a textbook a book entitled In the Matter of Color, which was written by a federal judge from Pennsylvania named Leland Higginbotham. And Judge Higginbotham was a brilliant legal scholar who studied the development of the laws in all of the 13 colonies and charted the peculiar development of the rights of Americans during the colonial period. For in each state, the laws were somewhat different. Although there was slavery in all 13 colonies, of course the northern states eradicated slavery before the southern states. And the southern states almost didn't really pick up slavery except for the invention of the cotton gin. But Judge Higginbotham found this one case out of Boston from around 1750, and it was a case of a ship that had a cargo of slaves that floundered onto the coast of Massachusetts. And the slaves had taken over the ship and killed the captain, but were too far away from home to make it back to the west coast of Africa.
Now, this was not the Amistad.
This was not the Amistad, no, no. This was another trial that was in Boston, and one of the key factors in the case, I mean, it was established that the crew had shipped out from Boston and sailed to Africa and had raided an African village on a Sunday. And the fact that the raid was conducted on a Sunday and that African village raid involved the shooting and murdering of many of the men primarily in the village, the fact that it happened on a Sunday was significant in freeing those slaves and having them returned and manumitted to Africa. Many people don't realize that the Constitution of 1789 protects slavery in several important planks. The Constitution that we're operating under now is the second Constitution. There was a loose confederation right after the Civil War, and when Dick Gregory was here, he indicated that a black man by the name of Barton was actually the first president of the United States, because there were actually 10 presidents before George Washington. But George Washington was the first president under the Constitution of 1789. And in the very first article of the Constitution, in section number 2, it states that with regard to the choosing of representatives, the number shall be determined by adding the number of free persons, including those bound to service for a term of years, excluding Indians not taxed, and 3/5 of all other persons. So in the first article of the Constitution, slaves were counted as 3/5 of a person with regard to apportioning representatives to the Congress. And in Article 4, Section 2, in paragraph 3, it states that no person held to service or labor in a state, if they escape to another state, they shall, in consequence of the law and regulation, be returned to their situation of labor or service in the previous state. So that if a slave should escape from bondage in the South and escape to the North, that northern state, the authorities in that state were bound by the Constitution to return those people back to servitude, and that is why many people escaped and went into Canada. And indeed, the Dred Scott decision, as late as 1857, reaffirmed the fact that escaped slaves could not be free even if they escaped to other states, and that African Americans were not considered to be citizens under the Constitution, at least under the interpretation of Justice Taney. Of course, this type of interpretation left no other alternative. I mean, when you appeal respectfully and reasonably and intelligently to the law, and the law is a law which upholds slavery, that is not a moral law. That is not a just law. And that is not a just law which an honest person is bound to respect and or honor. And consequently, all throughout the Americas, there were revolts opposing and contradicting these oppressive laws. In the United States, you have the rebellions of Gabriel Prosser and Nat Turner and Denmark Vesey. And of course in Haiti, the rebellion of Toussaint Louverture and Henri Christophe and Dessalines was successful in eradicating the French slavery rule. But also in Brazil, you have the Maroon town of Palmyra, which existed as a free African village in the interior of the state of Bahia in northern Brazil for almost 100 years, from the early 1500s, because slavery began in Brazil a lot earlier than it actually began in the United States and North America. Slavery coming to the United States in 1619 with that ship of 19 slaves setting out the indentured people in Jamestown. And Judge Higginbotham talks about the fact that even those first 19 slaves, they were not all committed to slavery in perpetuity. Some of them earned their freedom, and some of them even purchased slaves to and/or indentured servants to work their land that they'd accumulated over the years. So in the early days in the colonies, Africans like Europeans were brought to work off their passage, their indenture, which was usually 7 years, and then were freed. Only the Africans were later consigned to perpetual hereditary slavery.
Can you tell us a little bit about how that change came about? Because earlier, there were, before slavery in the United States, as you mentioned in South America, there were free Africans, and also in some areas of the Caribbean and even the other parts of the New World, there were free Africans, right?
Well, there were different situations about the freedom. For instance, in Florida, Florida was up until the purchase of 1820 by President Andrew Jackson, Florida was a Spanish colony.
Yes.
And as a result of the different governance, American slaves from Alabama and from Georgia would escape into Florida, and they amalgamated with the Indians, the Creek Indians, and they developed a tribe called the Seminoles. And that Seminole name is based upon a root of Cimarron, and that Spanish root Cimarron means runaway. And so the Seminoles were runaway slaves and Indians who amalgamated in Florida, and they had a whole nation, the Seminole Indian Nation. There was a fort, Pillow, which was blown up in around 1830 by Andrew Jackson's Union soldiers, and about 300 men, women, and children died in that massacre. Eventually, the Seminoles were forced out of Florida and driven to Oklahoma along the Trail of Tears with the Cherokees and the East Coast Indians, basically. And then they were run out of and chose to leave Oklahoma because of discrimination amongst some of the other Indian tribes, and they migrated into Mexico. A lot of them worked for Santa Anna, who was the president of Mexico at that time, guarding the border. After the Civil War, the United States asked the Seminole Indians who were living in Mexico to come back into Texas to help them track down Cochise and Geronimo and the Apache Indians, the Mescalero Apaches, because the Union Army could not track and or capture the Indians who were slipping across the Mexican border and into the states, into their hereditary territory. So a treaty was made with the Seminoles, and they were supposed to receive acres of farmland in exchange for their work as scouts for the Union Army in capturing Geronimo and corralling Cochise, which they did. But the Army reneged upon that deal, and there is a museum in southern Texas which displays that whole Seminole Indian history.
Very interesting. Well, tell us some more about the what happened after slavery was abolished in the United States?
Well, after slavery was abolished, there were three amendments that were placed into the Constitution. The 13th Amendment is basically the one which abolished slavery and involuntary servitude. The 14th Amendment guaranteed rights and privileges and the immunities of civilization, citizenship, due process, and equal protection of the rights to the freed slaves. And the 15th Amendment guaranteed the right to vote. After the Civil War, of course, Lincoln was assassinated, and then Andrew Johnson, his vice president, took over the government. There were many competing theories about how to deal with the South and how to best make peace. But you have to remember that many men in the South had taken up arms against the Union and were consequently rightly considered traitors. And in order to reclaim the right to vote, they had to swear allegiance to the Union. At first, the first Reconstruction legislatures elected former Confederates to be the heads of these legislatures, and they began to enact black codes which reimposed the former system of servitude and restrictions upon the slaves.
But wasn't there a period of time between
The legislature, Congress, American Congress, was incensed at this attempt to undo the progress of the Civil War, and they passed a regulation. All of this is involved with and is part of the reason why Andrew Johnson was impeached, because Andrew Johnson was allowing some of these abuses to go ahead. And senators like Charles Sumner and Senator Stevens were those who were advocating that the freed slaves should at least get 40 acres and a mule to begin to reconstruct a life, to compensate them some for the hundreds of years of free labor which had been contributed to the individual wealth of certain slave owners, but also to build the Congress of the United States, which was built with slave labor. The Capitol of the United States was built with slave labor, along with all the roads in Washington, D.C., and many of the East Coast states. All that infrastructure, the Erie Canal, and infrastructure like that was all built with slave labor. And so Congress passed a law that if you had taken up arms against the United States, you would have to swear allegiance and could not vote. That led to a new Reconstruction legislature in which black people participated greatly, along with many northern immigrants who came down to make their fortunes as well. But those first legislatures in around about 1868 up until 1874 put into place the first public school systems in the South. Before the Civil War, there were no public school systems in the South. Rich white people had tutors and or were sent away to school. Poor white people didn't go to school, or they caught their education the best way they could. It was illegal for black people to be educated, so you didn't have to worry about a school system for them. But the freed slaves realized that it was important to have their education, and they were the major impetus about putting into place the first public school systems for all people in the southern states of the United States.
These are the freed African who were in the legislature.
Those who were elected to the legislature. There were 22 African Americans elected to the United States Congress, and there were 3 African Americans who were elected to the United States Senate after the Civil War. Hiram Revels, Blanche K. Bruce, and Junius Pinchback. 2 were from Mississippi and 1 was from Louisiana. Pinchback was from Louisiana. He was also the lieutenant governor of Louisiana at one point.
And how long did this last, that the African Americans were in the legislature after Reconstruction?
It began to turn sour seriously with the disputed presidential election of 1876. The Hayes-Tilden election resulted in a basic tie, even amongst the Electoral College. And so that election was decided by, a smoky backroom deal. And Hayes agreed to remove the Union soldiers that had been maintained in the South as an occupying army to protect the 14th Amendment rights and the rights to vote of the freed slaves and to keep the peace. Hayes agreed to remove those soldiers, and that gave rise to the violent white supremacist organizations that were dedicated towards re-enslaving African Americans. And consequently, there were a series of murders and lynchings that went out from that period in time. There was a riot in New Orleans in which hundreds of, well, at least scores of black people were murdered. There's a book, Ida B. Wells did a book on lynching. There's a book, 1,000 Years of Lynching, by Howard Ginsburg. There are books called The Secret Societies, The Invisible Empire, dealing with the rise and fall of the Ku Klux Klan and that history. Because many of the legislatures, many of the sheriffs, many of the judges were secretly Klan members, and consequently the judicial system again was compromised, even though you had laws on the books calling for fair treatment, calling for equal treatment. The judges refused to enforce them correctly, and that culminated with cases called the slaughterhouse cases and the civil rights cases of 1878, which basically ruled that the 14th Amendment didn't mean what it said, that the federal government would no longer protect African Americans from discrimination by the states and or private individuals. And then, of course, in 1896, the Plessy versus Ferguson decision codified a system of discrimination which legally existed in this country for another 60 years, at least up until the Brown versus Board of Education decision of 1954.
Tell us something more about the Plessy versus Ferguson.
Well, Plessy versus Ferguson was a decision involving the right to freely ride in the railroads. The Plessy versus Ferguson decision is directly related to the Rosa Parks case and the bus boycott of Birmingham later on in 1956 and 1958. But Plessy was an African American man who purchased a ticket, I believe it was in Tennessee, to ride the train. And he purchased a first-class ticket, and he was evicted and thrown off the train when he refused to move into a second-class car. He pressed his suit, and the Supreme Court ruled that separate versus separate but equal and discriminatory could be the law of the land. Justice Harlan's dissent in that case is the decision now which is recognized to have been the correct decision, and who knows what the history of this country would have been like if the justices had taken the correct and moral stand at the time that they were called upon to do it.
So actually the Supreme Court justices were not upholding the Constitution.
No, not really. They made politically expedient moves and interpreted the Constitution in a 180-degree manner, which set it on its ear and caused it to do something that the plain language of the 13th and 14th Amendment clearly did not intend.
Yes. So we see that there were several times that the United States government had the opportunity to protect the rights of all of the people, but backed away from protecting the rights of African Americans.
Unfortunately, that's true. And what really sticks with me and resonates is the denial of the 40 acres and the mule. That was part of the legislation that was put in place by Senator Sumner and Stevens that was vetoed by Andrew Johnson, excuse me. And at the same time, the United States government was giving away sections of land, whole sections of land. A section of land is 640 acres. So I remember Tom Cruise and Nicole Kidman did a movie about 10 years ago called Far and Away. And he played an Irish immigrant, a guy just off the boat from Ireland who was trying to make his way from Boston to Oklahoma so he could engage in the Oklahoma land rush for the Indian lands, which the United States had declared as vacant and was basically giving to European settlers in order to disenfranchise the Native Americans. These people were straight off the boat, had never even fought in any American war, had certainly not given generations of free labor to the United States to build the infrastructure. And on the one hand, the government's giving 640-acre sections to these immigrants and refusing to give a mere 40 acres to people who have hereditarily been kept in bondage by the United States government and its agents.
Who have been so much a part of building the whole country, the infrastructures, as you mentioned, the Washington Capitol and everything like that.
The Capitol, the White House.
And of course the wealth of the people of the South.
The corporations, the insurance companies that financed the slave ships and insured the cargoes. All of those companies, various companies like Solomon Brothers, who raised the capital for the slave ships and to invest in slave cargoes, are still trading on the stock market today.
You have some other material that I'd like you to quickly show to us in the few minutes that we have remaining.
Yeah, this is a book on Maroon Societies. Columbus writes in his journal that when he pulled up on the shores of Hispaniola and visited Central America, the Isthmus of Panama now, the territory called Darien then, that he encountered African settlers. There was an African village at Darien in the 1400s before Columbus touched down. And he mentioned seeing them in his own handwriting. In fact, Columbus had been a slave dealer for the Portuguese for 20 years before he made the trip to the New World. And in his journal, he states that he talked with the African fishermen and sailors that he met in Africa and learned that the current from the Cape Verdean Islands, which are 500 miles off the west coast of Africa, takes you to the Caribbean. Gunnar Hardal, a Swedish explorer, put together a ship made of papyrus and caught that current in the 1960s and sailed to within 10 miles of the Bahamas to prove that the ancient Egyptians could have made that trip with their papyrus boats thousands of years before Columbus made the journey. In fact, just as an aside, there are boats buried in the royal cemeteries of the Great Pyramid, showing that the pharaohs were indeed seafaring individuals and had fleets. But the point that I'm making is that African Americans are free by nature, as are all human beings. The system of civilization itself arose in Africa along the banks of the Nile, coming up from the Olduvai Gorge. This is a video that my wife and I have done on ancient Egyptian history. And we go into the Cairo Antiquities Museum and show you pictures of the ancient pharaohs and queens. We've also done a piece about ancient Nubian history, and this is a statue of Amenophis III, pharaoh of the 18th dynasty, that stands in a temple at Wadi Sabua in Nubia. And this is the 25th dynasty pharaoh Taharqa. This statue is in the British Museum. But the history of civilization, traces its roots down the Nile River. And to understand this process, one really needs to take a look at the ruins of the ancient temples, which still line the banks of the Nile River for thousands of miles, showing evidence of that ancient civilization upon which all other civilizations sprouted, as humanity itself sprouted from old Africa.
Well, that's a very important point, because so many people disassociate Egypt from Africa and don't realize that the civilization that they speak of as Egyptian civilization was African civilization. I wish we could go further, but our time is running out. You have so much to offer, and you have given us so much, and I'm hoping that the viewers will now be able to at least critique some of their misconceptions, hopefully overcome some of them, and try to find out more about what actually is the history of the peoples of Africa.
I hope so. We have a website at aripeidea.com where we have some more text and photos and video clips that are available discussing the international African history. It's a fascinating subject with many chapters all over the world.
Yes, well, thank you so much for bringing this to us, Andre.
Thank you for having me.
I'm so happy to have you on the show, and perhaps we will go into this more at some later date, because I know you have so much more that you could give us, and I'm enthusiastic to share with us. Thank you so much.
Thank you very much.